Friends, thank you for being here today. We find ourselves at a moment in history that scholars, legal experts, and everyday citizens will likely discuss for decades to come. It is a moment where the intricate machinery of our justice system, often grinding slowly and quietly, has suddenly shifted into a high gear that few of us ever expected to witness. We are gathering to make sense of a startling event that took place in a federal courtroom, an event that signals a profound change in the legal landscape surrounding Donald Trump. For years, we have watched a seemingly endless parade of legal battles, motions, delays, and counter-motions. To the casual observer, it often felt like a game of stalemate, where consequences were theoretical and deadlines were flexible. But on January 1st, 2026, that dynamic shattered. The stillness of the courtroom was broken not by a gavel, but by the furious eruption of a judge who had, until this very moment, been viewed by many as one of the former president's most reliable judicial allies. I am talking, of course, about federal Judge Aileen Cannon. The headlines you may have seen, "Judge explodes," "threatens cuffs," "spoliation," are not exaggerations. They are the sober reality of a hearing that went drastically wrong for the defense. To understand why a judge known for her previous leniency would suddenly threaten a former president with immediate incarceration, we must peel back the layers of this story. We must look at the evidence that was presented, the smoking gun video that changed everything, and the testimony of an insider who decided that loyalty had a limit. To truly grasp the magnitude of this shift, let us transport ourselves directly into that courtroom. The date was January 1st, 2026. The atmosphere, by all accounts, was tense but routine. The legal teams were gathered to discuss procedural matters related to the staggering $1.5 billion fraud judgment that has been hanging over Donald Trump's business empire. The expectation was perhaps another delay, another argument about discovery, another day of legal maneuvering. However, the prosecutors arrived with something new. They did not come with mere arguments, they came with visual proof. As they laid out their case, the demeanor of Judge Aileen Cannon began to shift. This is a judge who has faced intense scrutiny and criticism for her past rulings in the classified documents case, rulings that many legal scholars argued were overly favorable to the defendant. Yet, as the evidence played out on the screens in that courtroom, the color reportedly drained from the faces of the defense team, and a look of genuine shock and then fury crossed Judge Cannon's face. When the presentation concluded, the silence was deafening. Judge Cannon did not call for a recess. She did not ask for a written brief. She exploded. Witnesses describe a scene where the judge, visibly shaking with anger, leaned over the bench and delivered an ultimatum that stripped away all the usual decorum of federal proceedings. "Turn over everything or face cuffs," she stated. Let those words sink in. Or face cuffs. This was not a rhetorical flourish. This was a specific, actionable threat of criminal contempt. She made it clear that the court's patience had not just run out, it had been incinerated by the evidence she had just witnessed. She was threatening to have a former president of the United States taken into custody, right there and then, if compliance was not immediate. Why? What could possibly provoke such a reaction from this specific judge? The answer lies in a legal concept known as spoliation, a dry term for a devastating act, the deliberate destruction of evidence. Now, to fully understand the depth of the judge's fury, we have to examine the specific act that triggered it. This case revolves around a $1.5 billion fraud judgment. To prove that fraud and to determine the true value of the assets involved, the court had subpoenaed specific financial documents, ledgers that would show the real, uninflated value of properties like Mar-a-Lago, Seven Springs, and Doral. The court had issued a preservation order. In plain English, this is a judicial command that says, do not touch, delete, or alter any documents related to this case. Keep everything exactly as it is. Violating a preservation order is bad enough. It can lead to sanctions or fines. But what prosecutors revealed was not a simple mistake or a clerical error. They presented surveillance footage from Mar-a-Lago, dated June 2022. In this video, we see Donald Trump himself. This is not hearsay. This is not a witness recounting a conversation from memory. This is the man himself, captured on high-definition security cameras. The footage shows him speaking to staff members. The audio, which prosecutors have enhanced and verified, captures a directive that is chilling in its clarity. Wipe those ledgers, The command was short, direct, and explicit. Wipe those ledgers. What makes this evidence so damning? What makes it a smoking gun, in the truest sense of the phrase, is the timing. Prosecutors laid out a timeline that left no room for doubt. Just hours before this video was recorded, Trump had been personally served with a subpoena demanding those exact ledgers. Imagine the sequence. In the morning, the subpoena arrives saying, "You must legally preserve these financial ledgers." Then, that very afternoon, the surveillance camera captures the defendant telling his staff, "Wipe those ledgers." There is no way to spin this as a coincidence. It wasn't that the documents were lost in a flood, or that a computer server crashed, or that an intern pressed the wrong button. This was a deliberate, calculated decision to destroy the very evidence the court had demanded. It was an act of defiance that struck at the heart of the judicial process. I want to pause here and ask you a question, because your perspective matters. If you were the judge sitting on that bench, and you saw this video after issuing a court order, how would you react? Would you feel betrayed? Let me know your thoughts in the comments below. But friends, we must dig deeper into the forensic reality of this situation to understand why the defense had no answer. In the digital age, the command "wipe those ledgers" reveals a fundamental misunderstanding of how modern technology works. When you delete a file from a server or a computer terminal, it does not simply vanish into the ether. The data leaves a ghost behind. It leaves metadata, information about when the file was created, who accessed it last, and crucially, exactly when it was deleted. Prosecutors didn't just bring the video, they brought the digital autopsy. They brought in forensic specialists who had imaged the servers at Mar-a-Lago. These experts testified that while the content of the ledgers might be gone, the access logs remained. These logs painted a picture that matched the video frame for frame. At 2:15 p.m., the video shows the staffer nodding and walking toward the office. At 2:20 p.m., the server logs show an administrative login. At 2:22 p.m., the specific folders containing the 2018-2021 valuation ledgers were purged. This level of synchronization is what legal experts call pattern evidence. It destroys the possibility of a rogue employee defense. If a staffer had just decided to clean up some disk space on their own, the timing wouldn't align so perfectly with the boss's verbal order. The digital footprint proved that the video was not taken out of context. It was the kickoff of a digital crime. For a judge, any judge, this is the ultimate insult. The court system relies on the assumption that parties will follow orders. If a litigant can simply destroy the evidence that proves their guilt, the entire system collapses. Judge Cannon realized in that moment that she was being played. She realized that while her court was issuing orders, the defendant was actively dismantling the truth. As if the video were not enough, the prosecutors had a second card to play, a card that often proves fatal in criminal and civil conspiracy cases: the flipper. Video is powerful, but it can be impersonal. A jury or a judge sees a figure on a screen, but a witness brings the story to life. Prosecutors revealed that they had secured the cooperation of a Mar-a-Lago staffer who was in the room when that order was given. This individual, whose identity is being protected but whose testimony was read into the record, has accepted an immunity deal. In exchange for telling the truth, they will not be prosecuted for their role in the deletion of the documents. This is a classic prosecutorial strategy. Get the little fish to testify against the big fish. Let us pause for a moment to consider the human element of this flipper. This was likely not a high-level executive or a millionaire consultant. This was a staff member, someone whose livelihood depended on their employment at the club, someone operating in an environment that has been described by former insiders as a culture of absolute loyalty. In such an environment, the boss's word is law, often superseding the actual law. The psychological pressure on this witness must have been immense. To turn against the most powerful figure in their world, to risk the wrath of his supporters and the loss of their community, requires a breaking point. That breaking point, according to sources close to the investigation, came when the staffer realized they were being set up to take the fall. When the investigation began tightening, the staffer noticed that the narrative from the inner circle was shifting to blame clerical errors by junior staff. Realizing they were about to be sacrificed to protect the boss, the staffer chose self-preservation. They walked into the prosecutor's office not out of malice, but out of necessity. This witness provided the crucial context that the video alone could not. They corroborated every second of the footage. Did Trump know about the subpoena? Yes, the witness confirmed he had just discussed it. Did the staff understand what wipe meant? Yes, there was no ambiguity. Did they actually delete the files? Yes. The witness described the atmosphere in the room immediately after the order. It wasn't frantic, it was business as usual. That details chills the bone. It suggests that destroying records wasn't an aberration. It was a standard operating procedure. The witness stated plainly, "We knew he meant delete. We deleted them, and he knew we did it." This testimony is devastating, but I want to hear from you. Do you believe this insider is telling the whole truth, or do you think there is more to the story? Is this the final nail in the coffin? Share your opinion with the community. Now, friends, let's move on to discuss what this actually means in terms of real-world consequences. We are not talking about a slap on the wrist. The repercussions of this revelation are cascading, creating what financial analysts are calling a death spiral for the Trump business empire. First, there is the criminal contempt. In the legal world, there are two types of contempt, civil and criminal. Civil contempt is usually about forcing someone to do something. Criminal contempt is punishment for past bad behavior. It is the court saying, "You broke the law by disobeying me, and now you must be punished." Judge Cannon explicitly stated that this blatant spoliation warrants criminal contempt. The penalty for this is not just money, it is jail time. She has the authority to order him incarcerated to vindicate the authority of the court. That is why she used the phrase face cuffs. But we must address the elephant in the room, the logistics of such an arrest. This is where we enter uncharted constitutional territory. We have never incarcerated a former president who is under the 24-hour protection of the United States Secret Service. If Judge Cannon were to issue that arrest order, a bizarre and tense standoff would ensue between two branches of federal law enforcement. On one side, you have the U.S. Marshals, whose job it is to obey the judge and take the defendant into custody. On the other side, you have the Secret Service, whose statutory mandate is to protect the former president from harm at all costs. How does that work in a jail cell? Does the Secret Service stand guard outside the bars? Do they insist on a private facility? Legal scholars suggest that any incarceration would likely be custodial confinement rather than a typical jail cell, perhaps confinement to a courthouse holding room or strict house arrest with ankle monitoring. However, the very fact that we are discussing the logistical mechanics of how to imprison a former commander-in-chief highlights the severity of the crisis. Judge Cannon knows this. She knows that issuing that order triggers a constitutional earthquake. The fact that she threatened it anyway proves that her anger outweighs her fear of the logistical nightmare. This is a scenario we've only seen in movies. Do you think the Secret Service would actually allow a former president to be taken into custody? Or would they intervene? I'm genuinely curious to hear your predictions on this. Second, consider the financial impact. The underlying case is already about a massive $1.5 billion fraud judgment. That is a staggering sum of money. But because of this new violation, this refusal to hand over documents and the active destruction of them, the court has imposed additional fines. The figure is $500,000 per day. Let's do the math together. That is $3.5 million a week. That is roughly $15 million a month. This is not money that can be paid with campaign funds. This is personal liability. At the same time, because the judgment is not being satisfied, the court has authorized the seizure of assets. We are hearing reports that properties like Seven Springs and the Doral Golf Resort are being placed into receivership or seized outright. The bank accounts are frozen. The revenue streams that keep the lights on at these massive properties are being diverted to the court. When you combine a $1.5 billion debt, a $15 million monthly penalty, and the seizure of income-generating properties, you have a financial catastrophe. There is no way to grow your way out of that. The banks are fleeing. The insurers are canceling policies. The empire is being dismantled, brick by brick, dollar by dollar. Third, there is the obstruction of justice. Beyond Judge Cannon's courtroom, federal prosecutors are watching. Destroying subpoenaed documents is a federal crime. It is a felony. This video evidence is likely already being packaged into a separate indictment for obstruction of justice. This carries a potential prison sentence that is separate from the fraud case. Even if the fraud judgment were somehow overturned on appeal, the obstruction charge would stand. Furthermore, we must look at the broader tapestry of deceit that prosecutors are weaving together. This incident does not stand in isolation. It connects ominously to the revelations from the Smartmatic trial documents, which have exposed a coordinated effort to manufacture false narratives about election finance. In that case, documents showed a deliberate strategy between campaign officials and media figures to promote lies they privately acknowledged were false. Why does the Smartmatic connection matter here? It matters because of a legal principle known as pattern evidence, or under the Federal Rules of Evidence, Rule 404B. This rule allows prosecutors to introduce evidence of other crimes, wrongs, or acts to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. The prosecution is building a pattern case. They are arguing that the destruction of the Mar-a-Lago ledgers is not a singular lapse in judgment, but part of a standard operating procedure that mirrors the Smartmatic findings. In both instances, the pattern is identical. First, a lie is told, inflating assets or fabricating election fraud. Second, when legal pressure mounts, there is a coordinated effort to suppress the truth. Third, when subpoenas arrive, evidence is destroyed or hidden. This pattern is lethal in a courtroom. It strips the defendant of the benefit of the doubt. A defendant might claim accidental deletion once. They might claim miscommunication once. But when prosecutors can show a jury that the defendant has a history of fabricating records and destroying evidence across multiple unrelated cases, the accident defense evaporates. It shows a mindset. It shows a guilty mind, or mens rea, which is the cornerstone of criminal liability. The ripple effects of this extend far beyond the borders of the United States. International legal observers are watching this case with bated breath. For decades, the United States has projected itself as the global standard-bearer for the rule of law. We lecture other nations on the importance of independent judiciaries and the principle that no leader is above the law. If a former president is allowed to openly defy a court order, destroy evidence on camera, and face no consequences, that moral authority is hollowed out. Diplomatic sources suggest that allies and adversaries alike are viewing this as a stress test for American democracy. Is the U.S. justice system strong enough to prosecute its own political elite, or has America drifted into the territory of a banana republic, where the law is merely a weapon used against the weak but ignored by the strong? Judge Cannon's ultimatum, turn over everything or face cuffs, suggests she is acutely aware of this global audience. She knows that her courtroom is the stage upon which the legitimacy of the American legal system is being auditioned. If she blinks, she confirms the cynicism of critics who say the system is rigged. If she acts, she validates the integrity of the institution she serves. This is why her fury is so significant. It is the fury of an institution fighting for its own survival. And let us not overlook the chilling effect this has on the former president's remaining circle. The flipper in this case, the staffer who testified, sends a terrifying message to everyone else in Trump's orbit. It signals that the wall of silence has been breached. If one staffer has flipped, how many others are quietly talking to prosecutors? In every conspiracy, the prisoner's dilemma eventually takes hold. The first person to talk gets the deal. The last person to talk gets the prison sentence. The revelation of this witness likely triggered a wave of panic among other aides and lawyers who may have been involved in similar activities. They are now looking at their own potential liability and wondering if they should be the next to walk through the prosecutor's door. It is impossible to view this moment without looking back at history. The parallels to the Nixon era are striking, yet today's situation is arguably more perilous. In 1974, during the Watergate scandal, the nation was captivated by the 18 1-2-minute gap in the White House tapes. That gap, an erased portion of an audio recording, became the symbol of the cover-up. It was the physical manifestation of guilt. But in Nixon's case, the erasure was clumsy, and crucially, we never had video of Nixon saying, "Erase that tape." We only had the aftermath. We had to infer intent. Today, technology has stripped away that ambiguity. We don't just have the gap, we have the order to create the gap. We have high-definition video of the cover-up being commissioned. Historians will likely note that while Nixon resigned to avoid impeachment and prosecution, the current strategy seems to be total defiance. But defiance runs into a hard wall when it meets indisputable evidence. The Nixon defense, that if the president does it, it means it is not illegal, has been rejected by courts time and again. Judge Cannon's reaction is the latest and perhaps most significant rejection of that philosophy. She is effectively saying that the courtroom is not a political stage. It is a place of law, and in a place of law, you cannot destroy the evidence. This leads us to a critical question. Why does this specific hearing matter so much, more than the dozens we have seen before? It matters because of Judge Cannon. For a long time, the narrative among Trump's supporters and his detractors was that he had a judicial firewall. He had appointed hundreds of judges, including Judge Cannon, and the belief was that these judges would always give him the benefit of the doubt. They would delay trials, limit evidence, and rule in his favor whenever possible. And for a while, that seemed to be true. Judge Cannon had previously made rulings that delayed the classified documents trial, rulings that were highly criticized. But there is a line. There is a line between interpreting the law favorably and ignoring a crime committed in your face. By ordering the destruction of evidence that her court had ordered to be preserved, Trump embarrassed the judge. He showed a lack of respect for her authority. He put her in a position where she had to choose between her loyalty to him and her oath to the Constitution. When faced with video evidence of a defendant mocking a court order, Judge Cannon had no choice. If she had ignored it, she would have destroyed her own career and reputation. She would have been complicit in the obstruction. Her explosion, her eruption in fury, signals the end of that judicial safety net. If Judge Cannon is threatening to arrest him, there are no safe harbors left. It sends a signal to every other judge in the country. The time for deference is over. The evidence is too strong. The behavior is too brazen. Beyond the courtroom, we must also look at the calendar and the political reality. We are in 2026. The midterm elections are approaching. For decades, the Republican Party has branded itself as the party of law and order. It is a powerful message that resonates with many Americans, especially those of us who value safety, stability, and the rule of law. But how does a party run on law and order when its leader is caught on high-definition video ordering the destruction of evidence? How do you explain that to a voter in a swing district? The footage is devastatingly simple. It doesn't require a law degree to understand. You see a subpoena, you see the man say, "Wipe them," you see the files vanish. Democrats are already using this footage in campaign ads. It speaks for itself. It strips away the argument that this is a witch hunt. A witch hunt implies you are innocent and being chased for no reason. When there is video of you breaking the law, you aren't a victim. You are a perpetrator. We are seeing reports that Republicans in competitive districts are panicking. They are scrubbing references to Trump from their websites. They are declining to comment. They know that this video is an anchor that could drag them down. The base may remain loyal, but elections are won in the middle, and the middle does not like obstruction of justice. There is also a profound sense of fatigue setting in. Even among those who have supported the former president, there is a quiet exhaustion. How many crises can one movement sustain? How many times can you ask your supporters to disbelieve their own eyes? When the smoking gun is this literal, the mental gymnastics required to defend it become exhausting. Political analysts are beginning to see cracks in the polling data. Not a sudden collapse, but a slow erosion. It is the erosion of trust, the erosion of enthusiasm, and the erosion of the belief that he can actually win against the weight of his own legal baggage. For my Republican friends watching today, I value your perspective immensely. Does this hard evidence change how you feel about the upcoming midterms? Does it change your view of the party's future? Please, let's have a respectful conversation in the comments. So, where does this leave us? Friends, we are left with a situation that is as volatile as it is historic. The illusion of invulnerability that has surrounded Donald Trump for his entire adult life has shattered. For years, the strategy was simple: delay, deny, attack. It worked because the legal system is designed to be cautious. It worked because witnesses could be intimidated or bought off. It worked because there was always plausible deniability. He could always blame a lawyer or an accountant. but you cannot blame a lawyer when the voice on the tape is yours. You cannot blame an accountant when the witness says, "He looked me in the eye and told me to do it." Judge Cannon has drawn a line in the sand. Turn over everything or face cuffs. The deadline is imminent. Trump is now in a box of his own making. If he hands over the documents, he admits to the fraud and loses the $1.5 billion case. If he refuses or cannot produce them because they are destroyed, he goes to jail for contempt. The death spiral is real. The money is running out. The properties are being taken. The judges have turned against him. The witnesses are flipping. We are witnessing the grinding gears of justice finally catching up. It is a reminder to all of us, regardless of our politics, that in the United States of America, the law is still king. No man, no matter how powerful, no matter how wealthy, and no matter what office he once held, is above the simple command of a court order. As we watch the news in the coming days, keep your eyes on Judge Cannon. Her next move will determine whether we are a nation of laws or a nation of men. Based on her fury on January 1st, it appears she has made her decision. Now, we wait to see if the defendant will finally, for the first time, face the full weight of the consequences he has courted for so long. Thank you for reading and for paying attention to this critical moment in our democracy. If you found this report insightful, please consider subscribing to our channel and sharing this with a friend who needs to know the truth. And finally, tell me, is justice finally being served, or is this just another chapter in a never-ending saga? I'll be reading your comments.